Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Illinois, my God. I tell you, when you guys fight in Illinois, you all fight nasty, okay? We're going to go back and we're going to trace the history of House Bill 5471, that assault weapon ban. And let us not forget what all the sheriffs have told the governor about this. And now the lawsuits are beginning to fly around. Well, when we go back and we take a look, one, at what the state legislature did to the citizens of Illinois, and number two, we take a look at what the state attorney is saying about the citizens of Illinois, it should have all of you, no matter what side of the fence you're sitting on, asking, what the hell's going on in that state? So today, let's spend a few minutes and talk about when a state government despises all of its citizens. Okay, so the issue we are talking about yet again today is now codified Illinois House Bill 5471, better known as the assault weapon ban of 2023. Now, many of you who've been geeking out on this channel may not know the rather sordid and horrific history behind this bill, but if you want to understand why the folks of Illinois are worked up about this, you really do need to have a historical perspective on what happened here. So let's go back in our little time machine here and let's talk about it. You see, House Bill 5471 was first introduced in January of 2022. Now, it didn't get a lot of fanfare because it was a boring, terrible piece of legislation that dealt with three statutes dealing with the Illinois Insurance Commission and how claims were reported and reimbursed. And I don't even know. I fell asleep trying to even read what it was about. But that's what 5471 was about. And it did its usual thing that these boring regulatory statutes do, which it ping-pongs around in committees, every committee getting their chance to get their fingerprints all over it. And by the time the 22 legislative session had come to an end, House Bill 5471 basically had gone nowhere. It sat in committee. It wasn't dead, but it just hadn't gone anywhere. Okay, so why are we even talking about House Bill 5471? Well, come January of this year, in fact on January 3rd, House Bill 5471 is suddenly pulled back in to the Assignments Committee. What's the Assignments Committee? Well, that's a committee of 6 House representatives, 4 of which happen to be Democrats, 2 of which happen to be Republicans, where they can assign a new legislation under the House bill. And what happens to House Bill 5471? Everything after the enactment clause. What I mean, anything after the following words, be it enacted that, everything else gets taken out. And then the Illinois legislature drops in language saying, well, this is all about human trafficking and all of the horrible weapons that are being used in human trafficking, such as assault weapons and all of these things. And that is where the assault weapon ban comes from in Illinois. Now, this basically goes into assignments on January 3rd. Not a big deal. It happens. I went back. And by the way, if you doubt any of this information that I'm telling you, because, you know, at Washington Gun Law, we try to give it right down the middle. We try to tell you guys what to think about, not how to think, okay? You can go to this link right there, okay, and you can look this bill up for yourself. And this history comes straight off the Illinois legislative webpage. So, it goes into assignments on January 3rd. By January 8th, just 5 days later, 5471 is born again. But it is now the complete and utter assault weapons ban. So, that of course gives the folks in Illinois some opportunity to weigh in and for this to go through the normal legislative process, much like the insurance laws were previously, right? No, au contraire. Because see, on January 9th, 1 day later, this bill is read on the House floor and it is passed by the Illinois House of Representatives. 1 day after it went from an insurance bill to an outright assault weapons ban. That's January 9th. Guess what happens on January 10th? Yeah, it goes in front of the Senate. It's read on the Senate floor. It's voted on the Senate floor. It passes the Senate floor. So in less than 72 hours, this bill went from some insurance regulation to an outright assault weapon ban passed and signed out of both houses. On January 10th, the same day, the same freaking day that it passes out of the Senate, it ends up in front of Governor Meister Berger, who of course immediately signs it into legislation, and the enactment date is in fact that date. So this piece of legislation went from January 8th, where it was a piece of insurance regulation, to a passed and signed assault weapon ban by the governor of Illinois in 72 hours. Now, the lawsuits have obviously already started flying. And one of the lawsuits is Accuracy Firearms v. Pritzker. Now, that lawsuit is filed in the Circuit Court for the 4th Judicial Circuit in Effingham County. And that is the subject of some of the injunctions that are currently in place. Now, before I started recording this video, and special thanks to our good man on the scene out there in Illinois, Todd H. Todd, thank you so much for sending this to us. Todd H. sent us a filing in the Circuit Court on the 2nd Judicial Circuit in White County, Illinois. This is the case that we're going to call right now Bailey v. Pritzker, but there's about 2,000 named plaintiffs. And kudos to the person who ever typed out the pleadings here, because there's a lot of names here. But this is an exact same motion here in White County for an injunctive relief there as well. So we're beginning to see the lawsuits drop. But when we go back to that very first lawsuit, the Accuracy Firearms v. Pritzker, there were two really unique arguments, because obviously these bills are all being attacked on Second Amendment grounds and for obvious reasons. But there was some other procedural attacks basically saying, hey, listen, the Illinois state legislature has a very specific procedure that needs to be followed when we pass laws. And it actually includes allowing the public to be informed of what's going on and to be heard about it. Shockingly, they call this representative government. And it also includes some things such as a single subject rule, which is essentially that, hey, bills need to cover just one subject. They can't have broad-ranging subjects, otherwise they're invalid on its face. And then the second thing is that whenever a bill is significantly changed, like, going from being about 3 pieces of insurance regulation that no one gives two you-know-whats about to suddenly banning the most popular sporting rifle in America, that, people might want to be informed on it. So the Illinois state constitution also requires that the bill be read 3 times in the House and 3 times in the Senate. None of that occurred here. And of course, you can imagine in the legislative light speed that this was traveling in, that there was no way that this was ever going to occur. Now, in the suit, and I have here the transcript from that particular case, okay, it's very interesting to take a look at what the Illinois state's attorney is saying here, because when these arguments are being made by plaintiff's counsel, for example, the first one, hey, listen, you changed this bill instantly. We had no public hearings. There was no public comment. They didn't even read the thing but once on each floor and then vote immediately. The public had no opportunity to weigh in. What was the Illinois state's attorney's response? Because Illinois, you need to be aware of how your state government views its citizens. Question from the court. Are you suggesting that we no longer have the right to look behind the curtain? Answer from the state's attorney. Yes, and I'll explain why. The 1970 Constitutional Convention specifically contemplated the use of the enrolled bill doctrine to prevent the invalidation of legislation on technical or procedural grounds. It, quote, determined that the legislature would police itself with respect to procedure. And so what the state's attorney is saying is, hey, listen, yeah, I know we got these rules, but hey, we should just let the legislature police itself. And if the president of the House and the president of the Senate both certify that they complied with the procedures, even though they didn't, but if they certified they did, that's all that the law really requires. That is actually one of the arguments that the Illinois state attorney is making here. Now, Illinois, do you think that you should have the right to be involved in the legislative process? Well, guess what? The Illinois state attorney does not. This is exactly what their response was. There is no right belonging to an individual to participate in the legislative process. That is from the Illinois Supreme Court, and they cite Formallo v. Chicago Board of Education. There is no individual right to participate in the legislative process, due process, or otherwise. And so your state attorney is arguing before a court of law that you as an individual resident of the state of Illinois do not have a fundamental right to be involved in the legislative process. Now, of course, the court also pointed out with questions like, hey, listen, if you change this law and go from insurance regulations to banning all these rifles, you do it in less than 72 hours and you make the law enacted immediately, how can any citizen even educate themselves or be prepared to be in compliance with the law? This is the question from the court. I want you to pay attention to what the answer was from your Illinois state attorney. Question. Let me stop you right there. How are citizens or legislators themselves supposed to familiarize themselves with something that has been on the books for almost a year and was changed within 2 days and had no public hearings or opinions? Or how are we supposed to get legislative intent out of that? There is nothing. How are we supposed to get that? And in brushing it off, the state attorney specifically stated, what the U.S. Supreme Court is referring to here is the opportunity of people to familiarize themselves with how they are being regulated before they are punished for their conduct for not complying with the regulation. They are all familiar with it. They hired Mr. DeVore and filed the lawsuit within less than 2 weeks. To the extent there is any concern, that's a defense for an individual to raise in a criminal prosecution to say that my due process rights have been denied because I didn't know that the conduct that you are now trying to hold me liable for is conduct that I can be held liable for. So, to break that down in simple English, they're saying, hey, listen, you can raise that objection when we're prosecuting you under this law. And of course, their objection to your objection will be, ignorance is no defense of the law. They literally are saying that you have no right to the legislative process, and you candidly have no right to know what the law is or how you're being regulated. And if you got a problem with it, you can raise that objection during the trial in which they're trying to put you in jail for it. And then finally, if you aren't offended by how they think of individuals, let's think about how the state government views small, locally run businesses. Because one of the things that are being argued here for temporary injunction is the irreparable harm. Because you have hundreds and hundreds of FFLs in Illinois who literally overnight have inventory that they can no longer sell. And that candidly is an unconstitutional takings clause, but I digress. But there is absolutely positively irreparable harm. You have literally ruined their ability to make income and thus probably keep the doors open and the lights on. What was the state's attorney's response when the court confronted him with that? Well, it was this. And for those who sell assault weapons, at most we'd be looking at a reduction in sales. But notably, Your Honor, we don't have any affidavits in front of you with any information or even allegations in either of the verified temporary restraining orders or the verified complaint arguing how many of these assault weapons do they sell a year. How many do they sell to individuals versus to the United States government? We don't have any of that information to be able to assess that in the plaintiff's burden here to show that they would be irreparably harmed. And then the court followed up with this question, and listen to the answer. Counsel, isn't a reduction in sales an immediate and irreparable harm? Answer, no, Your Honor, because it would have to be a reduction so great that it essentially puts the plaintiffs out of business. So unless they completely put you out of business, there actually isn't any irreparable harm. And of course, once you're put out of business, not only is that irreparable harm, there is no possibility to get it back. When those doors are closed, those doors are closed. But folks, that is how the state of Illinois, and this comes straight from one of the assistant attorney generals here for the state of Illinois. Okay, this is your state's attorney speaking on your behalf. This is how your legislature treated you. This is how your governor treated you. And this is what your state attorney thinks of you. Listen, there's going to be a lot more lawsuits filing. We already got Accuracy Firearms v. Pritzker there in Effingham County. And then thanks to Todd H. today, we found out also about Bailey v. Pritzker, which is filed in White County. And there is at least 1,000 named plaintiffs in that. We will keep you posted as this goes on. There is a lot left to be told in this very long and terrible story. In the meantime, if you have any questions about what's going on in Illinois or anything related to what's left of your Second Amendment rights, remember, you can always contact us at WashingtonGunLaw.com or you can call us directly at 425-765-0487. In the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. Stay safe.